5 seconds to go. Start. Being aggrieved against the order passed by the Joint Commissioner dated 30th April 2013, both, the respondent dealer ESL and the state government preferred the appeals before the tribunal. Stop. That by order dated 29th January 2015, the tribunal allowed the second appeals preferred by the respondent ESL, holding that the respondent ESL is not liable to pay any tax, interest or penalty on the disputed transactions and dismiss the cross objections of the state. Stop. Para. Feeling aggrieved and dissatisfied with the orders passed by the tribunal, allowing the second appeals preferred by the respondent dealer assessee and dismissing the cross objection preferred by the state, and holding that the respondent ESL is not liable to pay any tax, interest or penalty on the disputed transactions, the state preferred the present appeals before the High Court, being tax appeal numbers 136 of 2016 to 140 of 2016. Stop. By impugned common judgment and order, the High Court has dismissed the said appeals mainly on the ground of promissory estoppel, and also observing that the respondent ESL has not violated any of the conditions provided under the original entry number 255-2 dated 5th March 1992. Stop. Para. Feeling aggrieved and dissatisfied with the impugned common judgment and order passed by the High Court, the state has preferred the present appeals. Stop. Para. Shri Maninder Singh, learned senior advocate appearing on behalf of the appellant state of Gujarat, has vehemently submitted that the impugned common judgment and order passed by the High Court is patently erroneous and unsustainable. Stop. Para. It is vehemently submitted by Shri Maninder Singh, learned senior counsel appearing on behalf of the state, that in the present case, the notification dated 5th March 1992 can be said to be a parent notification, and all other subsequent notifications dated 14th November 2000 and 16th January 2002 were either clarificatory in nature and or expanding the scope of exemption. Stop. It is submitted that in any case, subsequent notifications dated 14th November 2000 and 16th January 2002 amending the original entry number 255-2 cannot be said to be taking away any rights, which were conferred under the parent notification dated 5th March 1992. Stop. It is submitted that therefore there is no question of the promissory estoppel as applied by the High Court and the tribunal. Stop. Para. It is submitted by Shri Singh, learned senior advocate appearing for the state, that as per the original notification dated 5th March 1992 and as per the original entry number 255-2 and the statutory form number 26, it is abundantly clear that the parent notification dated 5th March 1992 extends the exemption only to within the eligible unit for utilizing the raw materials for manufacture of goods in that unit itself. Stop. It is submitted that the wordings used in the notification are clear and unambiguous, that the exemption shall become available only if the said eligible unit utilizes the raw materials for manufacture of goods in the very same within eligible unit. Stop.